Well, we're starting chapter 8 in your government book. We're talking about the federal courts now in the judicial branch. And this is set forth in Article 3 of the Constitution. Also, Amendment 11 has to do with the court system too. So we're talking about the third branch of government, which is the judicial branch. When you look at the word judicial, what do you think of? Judges. So we're talking about our court system, especially the Supreme Court. And we're going to do a whole section on the Supreme Court. The highlights of this chapter, the judicial branch, which are set forth in the Constitution, we'll talk about that today. On to the judicial process. What is the process of the court, our court system? And on to all about the Supreme Court. So I love what it says here. Comes right out of the Bible in Deuteronomy 16:18 through 19 says, "Judges and officers shalt thou make thee in all thy gates, and they shall judge the people with justice," with just justice. So just that part right there, judges and officers will sit in the gates, and they shall judge the people with just judgment, right judgment. Thou shalt not wrest judgment, thou shalt not respect persons, neither take a gift, for a gift doth blind the eyes of the wise and pervert the words of the righteous. The Bible goes on and specifically tells what just judgment shall be, right down to the 10 Commandments. And do you know in our Supreme Court, if you look above where they sit, there are the 10 Commandments. That's what our forefathers wanted to base our judicial branch on, is the Bible and the law of the Bible. And this came from Deuteronomy, just judgment. Also, Daniel Webster says, "Justice, sir, is the greatest interest of man on earth." So how important it is. Don't we all want justice? You know, without having righteous justice, when we have justice that's convoluted and corrupted, then we'll have a horrific society when right is wrong and wrong is right. And it's kind of getting that way lately in the United States in many respects. But we're going to talk about our federal court system set by the Constitution of the United States. So the judicial branch. Again, it was created in the Constitution in Article 3, Section 1 and 2 of Article 3. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may form time from time to ordain and establish. So the Constitution says this. Basically, it says that we're going to have one Supreme Court, and out of this Supreme Court, Congress is going to create inferior courts from the Supreme Court, you know, and we'll see how Congress does this. So we're going to have those coming down from the constitutional courts, and then we'll go over the legislative courts, both of those. But you can see here, this is the exact words from the Constitution. Only the federal court must exist. So the Supreme Court must exist, set down by the Constitution. The rest of the courts are created by Congress, right? And the Constitution gives power to Congress to create these inferior courts. Well, the first court of the United States from the Constitution was convened in 1789. And basically, when I say the first court, the first Congress did, and passed the Judicial Act of 1789. So the first Congress getting together, you know, they passed the Judicial Act of 1789, kind of a test question because it was the first bill ever introduced in the Senate. The first bill, the first law to go through the Senate at that time was the Judicial Act of 1789. Judiciary means what? Judgmental, judges, right? So Judicial Act of 1789. What did it create? What was this bill about? Well, it created a Chief Justice and 5 Associate Justices of the Supreme Court. You notice the name justices and judges sometimes can be intertwined. But when we talk, definitely you're talking of the Supreme Court, you talk of justices. You know, so there's one Chief Justice and 5 Associate Justices that were set forth. And under this, there would be 3 circuit courts, each consisting of 2 Supreme Court justices and 1 district court judge, and 13 federal courts. So they set here. We'll find out in the next, just a little, let's look here. Here's a picture of I like to see before I turn the page. Here's a picture of the Supreme Court building now that's in Washington, D.C. Hopefully you'll be able to go see it. It's pretty magnificent as going through, and there's a lot of scriptures in the midst, especially in looking in the Supreme Court above where they have the 10 Commandments set forth. So, but let's go back. It created what? Again, it creates for each, created first 1 Chief Justice and 5 Associate Justices for the Supreme Court, 3 circuit courts, and each one of these courts consist of 2 Supreme Court justices and 1 district court judge, and 13 district courts. So, and Congress has empowered both the courts and the judges that sit on them to interpret the laws and administer justice according to the Constitution. So I'm going to go on to the next page here first to show you. Here's going to be in brief the federal court system. So set forth the United States Supreme Court, and then you have the United States Court of Appeals, the United States Appeals for the Federal Circuit right here, the U.S. District Courts. We're going to be talking about all of this, and the United States Court of International Trade. We're going to focus on the district courts here. So all these in blue are constitutional courts that come out of Article 3 in the Constitution right here. And then we're also going to have legislative courts. And these legislative courts are basically legislative, meaning law courts. They're set forth by Congress. And of these, you're going to have the United States Tax Court, United States Territorial Courts, the Courts of District of Columbia, the United States Court of Federal Claims, the United States Court of Appeals for Veterans, and of course here you can also have military, the United States Court of Appeal for Armed Forces, and the Court Martial. So this has to do with armed forces. You can see all these in red are the legislative courts, law courts, legislative courts set up by Congress. And on we go here. These are our Constitution. The blue are constitutional courts. So, and we're going to go over what constitutes constitutional courts. So let's go back. So basically, the Congress has created 2 types of courts. So the constitutional courts and the legislative courts. And we just went over those 2 different types. But what is the difference? Let's talk about the difference. So we're going to start with the constitutional courts. Constitutional courts are those courts that are created under the authority of the Constitution. That's why we call constitutional courts of Article 3. So, and they exercise judicial powers of the United States. Judges are appointed by the president, and the president appoints these justices or judges, appoints them, but always having to be confirmed by the Senate. So once the president appoints one, it has to be, basically that person has to be confirmed by the Senate to go into duty as a justice. The thing is about the constitutional courts, especially when you talk about the Supreme Court, the justices are appointed for their whole lifetime, unless they get out of good behavior in some way. They're charged with some crime or something, and at that point they can be taken out. A lot of times they'll just want to retire. They can retire if they want on their own, or if they can die. But otherwise they're appointed for life. So these include, and I went over them all over on the other page, the district courts of appeals, those courts that are appealing, the Court of Appeals for the Federal Circuit, the Court of International Trade, and the Supreme Court. The Supreme Court is a constitutional court, but is not created by Congress. The Supreme Court wasn't created by Congress. It was mentioned in the Constitution. So the Supreme Court is the only one that's not, created by Congress. And then Article 3 also establishes the jurisdiction. So what's jurisdiction? Jurisdiction means the right of a court to hear and decide a case. Look at the word jurisdiction. Jurisdiction, it looks like. So jury looks like, when you look at a jury, you think of a court, right? And diction means a word. So basically the right of a court to hear the words of that person. That's jurisdiction. So Article 3, Section 2 establishes the jurisdiction, the right to hear a certain case in that court. And how do we know? What is the right? First of all, the right includes those two different reasons, two different things. First, the subject matter of the case. What's the case about? A certain subject matter goes straight to the constitutional courts. And then second, the parties involved. So if certain parties involved will go right to the constitutional courts, and they have federal jurisdiction. So you look at who is in the case and what is the subject matter of the case. Those two things. So what is this? When you talk about constitution, well, what is the subject matter of the case? So the subject matter of the case being, first of all, if the case has to do with the Constitution, it's going to go to the Constitutional Court. If it has to do with federal laws or treaties, it's going to go to the Constitutional Court, And also if it has to do with admiralty or maritime matters, that's shipping. It has to do with our shipping. It's going to go to the Constitution. Those are three different things that we know. If it has to do with any of these things, what it's about, they'll go to Constitutional Court. Now, if it has to do, includes certain parties, has to do with certain parties here, they have in the Constitution set by these parties, if they're involved, it will go straight to the Constitution. And there are 5 things mentioned in the Constitution. First of all, if it has to do with ambassadors, if it has to do with foreign ministers and consuls, it's going to go to the Constitution. If it has to do with the United States, like the United States versus Richard Nixon in the Watergate case, whenever United States has to do with one of the parties involved, it's going to go straight to the Constitution. Also, these 3 now, 3, 4, and 5, if it's a controversy between states, if it's a controversy between 2 citizens of different states, or a controversy between a state or a citizen in a foreign government, those set forth in the Constitution would go right into those constitutional courts. But since then, there was an amendment made to the Constitution after the Bill of Rights, and it was 11th Amendment in 1798, which says a state cannot be sued in a federal court by its own citizens and by the citizens of another state or by a foreign country. So that's the 11th Amendment. So a state can't be sued by what? By its own citizens, by the citizens of another state, or by a foreign country. That's the states. So this was set forward, which kind of amended these three set in the Constitution. Well, it did amend them. So the 11th Amendment sets forth. So when you look at here, you're basically going to look at ambassadors, foreign ministers, consuls, the United States involved in all this. This would go to the constitutional courts. Again, here's a picture of a federal court system with the Supreme Court, and the appeals to the Supreme Court are here in blue. And then, of course, the red, so the federal court system. So let's talk about the red here. What are these? What's the difference? What's the red? Are the legislative courts? What's legislative mean? Legislative means law, right? So the second time of court was created by Congress is the legislative court. The legislative courts have no jurisdiction that was mentioned in the Constitution under Article 3. So all these red ones were actually, they were created by Constitution, but they don't have any foundation in the Constitution in Article 3. So just knowing. So, and why were these, look here, why were they created? For taxes, for one reason, for territorial courts, to have the courts in the District of Columbia, all these court-martial, these two are court-martial and the appeals for the armed forces. These are in the legislative courts that were created by, and you can see they have reasons, reasons why the court would go through this system. So they basically are created to handle the appeals from specific cases arising from the powers granted to the Congress. So, and going on from that section there, these are listed again. So the judges of these legislative courts are appointed by the president, and of course the Senate has to okay them, but they only have, the judges of these courts, these red courts, these legislative courts here, they don't have lifetime terms. They only have terms of 10 to 15 years. So they only can be judges for 10 to 15 years, and then they have to retire, not lifetime. The constitutional courts, especially the Supreme Court, they're appointed for lifetime. So, and they include these things, and we went over those things already: the tax court, federal claims, District of Columbia, and the armed services. So federal judges and justices. So nominating federal judges. All federal courts, constitution or legislative courts, are presided over by a federal judge. And these judges, they're either Supreme Court justices or are the chief decision makers of the federal judiciary. So basically, these justices are the chief decision makers, right? Right here are the chief decision makers of the federal judiciary. So they're the chief, these judges. They are what? Nominated by the president, and then they have to be confirmed by the Senate. We already went over that. And in Article 3, Section 1, protects both office and salary of the judges on a constitutional court. So for the constitutional court, the salary and the office is protected. And of course, they serve for a lifetime, unless, of course, they would choose to retire or they're impeached. They did something wrong, so they're impeached. Then they have to leave or they die, of course. They hold fixed terms, and they do not necessarily enjoy guaranteed salaries, so basically, no, they serve for life. They hold fixed terms, and as for that, they also enjoy, or they do not enjoy necessarily fixed salaries, right? So they're usually the president's choice, but the president may have a choice in this, but also the American Bar Association, of course, the law, that's our law system. The American Bar Association is ABA, has a lot of say in who these justices would be too. And the president goes and looks to the Bar Association when he's nominating a president to see, what they say about this person to be a Supreme Court justice or a federal justice. So the Bar Association has the most influence on the president's choice. In 1878, a voluntary association of lawyers, judges, law teachers basically got together to foster high standards of jurisprudence, they call it. Jurisprudence is a judiciary prudence or good law, In 1878, they got together and put together on a committee, this committee of this federal judicial department, and evaluated federal court nominees. So they could have a 4-point scale to say how we're going to judge these nominees. Mostly of them have come through the law system on a 4-point scale, exceptional to not qualified on this 4-point scale. So they use a scale, the American Bar Association, to see how good this person, how well this person, I should say, does on their judgment of law, right? This is the ABA, American Bar Association. If you're a lawyer, you have to go through this too. So, but the president necessarily is not bound by what they say. He doesn't have to do it if he doesn't want to. But political consideration is very important to the president. Why? Because if a president wants to go ahead and nominate a court justice or pick a court justice, he wants to have that justice represent his beliefs in his political party, right? Say that he does not believe in abortion, then of course he wants a judge that does not believe in abortion, right? So usually political concerns are very important. So they basically to think best in the line of politics when they're picking justice. Example would be Ronald Reagan's Attorney General, Edwin Meese III. He interviewed to make sure that each of these justices that were appointed by the president shared the philosophies of the president before. So he investigated them for Ronald Reagan. So when Ronald Reagan picked those Supreme Court justices, that they would have his philosophy and politics in the midst of the Senate. So, and this, or in the midst of the court system. And so, of course, after the president appoints somebody, then the Senate has to approve, and that takes a while. So it takes a while. So it's so for this justice to take to be able to take his job, to become that justice, he has to go through the Senate approving him too. Not only confirmed by the president, but also by the Senate. So, and also the Senate may decide that they don't agree with the president. And there's this sanitary courtesy saying, okay, we're not going to agree, and let the president appoint that person. So, nominating Supreme Court justices. So they're chosen, the Supreme Court, let's go here. Nominating Supreme Court justice. Now we're talking about the Supreme Court. Actually, we're pretty much talking about other justices, but also now it's really important when we focus on the Supreme Court. They're chosen the same way federal judges are, and they're nominated by the president and confirmed by the Senate. We already went over there. Most of the time, the president's choice for the court is secure if he chooses a judge who is completely and highly regarded by his peers. But in recent years, liberal interest groups have exercised considerable political influence on key members of the Senate Judiciary Committee and other senators. This has had the effect of slowing down the confirmation process. So basically, Supreme Court justices are very important, right? And they're chosen just like the federal judges are chosen too by the president and confirmed, and they're confirmed by life. But now, whenever there's going to be a Supreme Court justice chosen, like I said before, you're going to have all kinds of political people involved in this to try to sway that choice and away from the president's choice. And so because politics is very important when it comes to the appointment of Supreme Court justice, whether they're the Republican Party or the Democratic Party, is really important to them. So just saying. And this slows down the confirmation. Now we have a lot of liberal interest now, and these liberal interest groups now getting in. We'll see why. I'll show you why. Actually, let's go back to this. This article here is so good. The focus. The reason everybody, whenever a Supreme Court justice dies, and a new one has to be nominated, that it becomes such an important political choice. And this is why. It says, a new struggle for intellectual dominance in the constitutional theory is underway at this moment. The struggle is about the duty of judges with respect to the Constitution. So what do these judges get to do? It is taking place now to figure out what they have to do. What they do is taking place out of sight in a sense because it's carried on mostly in the law schools and in law reviews and such, saying what can a Supreme Court justice do? And the ideas now win in what's called hegemony. Hegemony is how they will govern the profession, including the judges for the least generation and perhaps more. So basically, hegemony is like, what are the responsibilities of these justices going to be? What are they going to be allowed to do on their cases? So that's the hegemony. And this will affect the future. And it's going on right now, the liberal hegemony, trying to say, let's give the justices more, power. So here is the debate. There are some justices that take what's called interpretivism and then non-interpretivism. So those are the two, interpretivism and non-interpretivism. Well, what is that? What is interpretivism? And it is basically called strict constitution. Instead of saying the word interpretism, I'm going to say strict construction, or strict, I say strict constitution, but it is strictly going by the Constitution, strict construction, strictly interpreting it by the Constitution. And then there's non-interpretism, and it's what's loosely referred as to activism or imperialism, that they can actually interpret the Constitution having to do with cultural change. They can actually change the Constitution, what it says, in a liberal way. Here's what John Hart Ely of Harvard School says it is. Basically says that interpretism, or that judges decide constitutional issues, should confine themselves to enforcing the norms that are stated clearly, implicitly in the written Constitution. So what the non-interpretivism is, basically says the opposite. It insists that the work of the political branches is to be evaluated only in accord with inference or customs, right? That the contrary view, also this view, that the courts should go beyond that set of references from the Constitution and enforce norms that cannot be discovered within the four corners of the Constitution. So they're saying the non-interpretism, these liberal thinkers thinking, we can say, what does this infer beyond the Constitution? And that's what they're trying to do. So really they're remaking the Constitution on their own. If the theory of non-interpretivism says that judges can draw their constitutional rulings from outside the document, and this achieves entirely an intellectual hegemony saying what they're allowed to do in the law of school, the results will be disastrous for the constitutional law of this nation if this goes through. The judges will feel justified in creating new individual rights, from those influential groups, whichever group they want. And they can be basically changing the Constitution, the constitutional apparatus to their own desires. And now they're trying to get support that there will be much power given to these Supreme Court justices above what they've had in the past. Mostly in the past, they've just said, okay, it has to be either a constitution or a non-constitution. Now they can say, well, the Constitution is a little bit outdated and we're going to go beyond the Constitution. Not a good idea. So that's why it's so important, the philosophies in the hearts of the justices that are picked, and why people get so involved when a president is picking those judges or justices. So, okay. Let's go over the questions really quick and then we'll finish this section. What is created by Article 3 of the Constitution? What is the judicial branch, right, of government is created? So what act of Congress established the structure of the federal court system, and what was this structure? Remember that Judiciary Act of 1789 set forth the Chief Justice and at that time 5 associate judges in the circuit courts, 3 circuit courts underneath them with 2 justices and 1 district judge onto 13 federal district courts underneath. So that's what it set forth. That's the structure. Number 3, what is a constitutional court and how do judges serve on these courts? So a constitutional court are those courts that were created by the Constitution in Article 3, right? And the justices serve for life on these courts. Lifetime. Number 4, what types of cases fall under jurisdiction of the Constitutional Court? We went over those types. First of all, the subject matter, which if the subject matters of the Constitution, of the federal law or treaties or admiral or maritime ship, that's basically shipping and such. All this they was set forth has to go to the Constitution, and also the cases involved. If it's involved with ambassadors, foreign ministers, consuls, if it's involved, the United States is one of the parties, as the United States versus, Nixon or whatever. And also before it said controversies between states and controversies between the citizens of different states and between the state and the citizen and the federal government. But now the 11th Amendment has actually negated that part of it. So it says, what constitutional amendment prevents a citizen of one state from suing another state? That's the 11th Amendment. We have the Bill of Rights, which is the first 10 amendments, and then we have the 11th Amendment. Just remember, the 11th Amendment is the only amendment that has to do with the judicial branch or the court system. Number 6, what is a legislative court and how do judges serve on these courts? So legislative court was created not by the Constitution, but by Congress to handle certain appeals. That means to have those that are appealing to a higher court. So it's set forth by Congress for specific cases that are arising from powers granted to Congress. And the difference here, how long do these judges serve? These judges on the legislative courts only serve from 10 to 15 years. Remember, the others serve lifetime. The constitutional judges serve lifetime. They serve lifetime, but the legislative court judges only 10 to 15 years. So those were our questions. So here we go. Here's a picture of a courtroom in proceedings. You've probably seen these pictures in trials, and we're going to get into that in the next part. So the process.